All righty. Hello, everyone. I am Chris Timmel, one of the founders of PuzzleHR, and welcome to our Webcast Series, where we try to bring value to our clients and certainly to our community as well. I'm joined today by with Deanna Hayes of Ogletree Deakins. Deanna Hayes is a shareholder level attorney in the Ogletree Deakins Tampa Office. And Ogletree is one of the largest labor and employment law firms in the United States, representing management in all types of employment-related legal matters. The firm has, I didn't even know this, firm has over 900 lawyers across the U.S., Europe, Canada, and Mexico. That's wild. Now, Deanna is board certified in labor and employment law by the Florida Bar. She's a practical labor and employment lawyer who represents businesses in a wide range of labor and employment law matters, including counseling employers on workplace legal compliance issues, employment litigation defense, unfair competition and trade secrets litigation, workplace safety and health, so it's OSHA, it's important. And more traditional labor relations, so staying union free. She represents clients in a wide range of industries, and Deanna is also a nationally recognized speaker and an author on labor and employment law issues. And in full disclosure, Ogletree Deakins is the firm that we use here at Puzzle. And Deanna is, when we started the firm a few years back, she's one of the first people we called. And she's done just absolutely great work for us. So Deanna, thanks for spending some time with us today. We certainly appreciate you taking the time to talk about some of the things we're going to talk about. And welcome. Happy, it's right after the 4th, so happy right after the 4th.
Thank you so much. And thank you, Chris, for having me. It's a pleasure to be with you today. And I really enjoyed getting to work with PuzzleHR. And I know many of my clients have really appreciated your services as well. So thank you for everything that you're doing.
Oh, appreciate it. You're the best. So I thought this is timely. This is a topic that I think is really going to be important to our Florida clients and companies in Florida, but who knows, it could inform businesses across the state, across the country. So there was a new law that was passed in April by Florida legislators. What it's called, it's almost like the Stop Being Woke law or something like that. Why don't you describe it for us, Deanna?
Yeah, so that's the term that it's been given as the Stop Woke Act. It's also known as HB 7, which is the bill number when it was introduced into the House of Representatives in Florida, or the Individual Freedom Act. So basically, in April, Governor Ron DeSantis signed this into law. And what it does is it places limitations on the types of mandatory training employers can require of their employees when it comes to subjects like diversity and inclusion and equity in the workplace. And really, for those of you who are familiar with it or have been tracking the bill, it started off as an education bill and was primarily aimed at what children could be taught in schools. But then this workplace piece got tacked on that regulates what employers can say in the workplace on these topics. And I think from the start, why that's problematic is the school board has to approve courses that are taught in Florida schools, but there's no one out there that's going to approve employer workplace trainings, right? So it's up to the employer to review what's in the law and decide if their programs are going to be compliant.
So Deanna, this is the part of the Don't Say Gay bill, is what you're saying?
It's very similar. So it was separate from that, but it was in the same theme. And again, I think originally this was targeted at schools and education, and then gradually workplace trainings got added to this as well. And what this does is it actually amends the Florida Civil Rights Act to make it an unlawful employment practice to have trainings that are prohibited by the act, which is interesting to me as a legal nerd and a lawyer, because the Florida Civil Rights Act already prohibits reverse discrimination, right? So what this is intended to prohibit could already be actionable under the Florida Civil Rights Act. It's just calling out trainings as something that would be a separate unlawful employment practice.
Okay, got it. So that's what it does. So it's this is what you and I talked about probably a couple of weeks ago, right? When it's already in the law, but this just kind of puts a finer point on it.
Yes, it does. And I will go ahead and share with you the 8 concepts that are prohibited by the act. And bear with me because they're wordy, but I think it's important to get through this piece so you understand exactly what's in here. But what it says is effective July 1st. So just became effective right after the holiday. Now everyone's getting back to work and is going to be thinking about this perhaps, but it amends the Florida Civil Rights Act to make it an unlawful employment practice to require employees to attend training that espouses, promotes, advances, inculcates, or compels the individual to believe any of the following concepts. Number 1, members of one race, color, sex, or national origin are morally superior to members of another race, color, sex, or national origin. And those are the categories that are addressed throughout this law: race, color, sex, and national origin. So I'll just call them protected categories going forward so that we all understand what we're talking about. But also that an individual, by virtue of his or her protected category, is inherently racist, sexist, or oppressive, whether consciously or unconsciously. So that really goes to your unconscious bias trainings. And I've been asked by some national employers to take a look at their training programs to see if anything might run afoul of the law. And that's one of the areas where I have seen it come up, where trainings might say something like people develop unconscious bias by a certain age. So language that implies someone has an unconscious bias and there's no way around that, or one group is inherently racist towards others or inherently sexist. That's the kind of language that might run afoul of the law.
Mm-hmm. So even stating like the psychology aspect of it, that people have unconscious biases, runs afoul of the law, or could.
It could, if we're requiring employees to believe it, right? So one of the things that we can talk about is, what are some ways that employers can deal with these topics? So one, just making it clear that we're just having an objective discussion, right? We're not requiring you to believe this, but this is something educational about, the history of diversity, equity, inclusion issues, and letting them know that, while we think this is helpful background information, that they're not required to believe it as a condition of employment.
Okay.
Also, that an individual's moral character or status as privileged or oppressed is determined by a protected category. That members of one protected category cannot and should not attempt to treat others without respect to their protected category. So I think this one was kind of confusing to me when I read it. And I think where it's going.
See the look on my face.
Right. I agree. I don't know if you are familiar with the concept of color blindness and someone saying, oh, I don't see color, I don't see race, in an attempt to try to say that person is not being racist because they're not judging someone because of their race or their color. Whereas there's been some educational materials provided more recently that say that's not enough. You should see race and you should see color and you should respect everybody despite the differences in their race or their color, because that's part of their inherent identity and who they are. So this law kind of butts heads with that type of language, saying that it's not okay to say I'm colorblind and leave it at that.
Gotcha. Okay.
And then the next pieces are an individual by virtue of their protected category should be discriminated against or receive adverse treatment because of actions committed in the past by other members of that same protected category. So this kind of goes to the concept of affirmative action, right? Or displacing one person in favor of another because they were historically displaced.
Okay.
Also, I know, and federal contractors are probably just really scratching their heads at this point with affirmative action because they are required by federal law to have affirmative action programs. And I think the spirit of this isn't that there can't be some form of affirmative action, because even when you have a program like that, you are still allowed as an employer to choose the most qualified candidate for the job, right? You're just making efforts to try to increase your pool of diverse candidates so that you have more opportunity for the best qualified qualified person to be a diverse candidate. So I don't think you are violating one versus the other. It's just in how it is applied.
Gotcha.
Okay. And then the next one is very similar, that an individual of one protected category should receive adverse treatment to achieve diversity, equity, or inclusion. So I'm not going to consider any candidates from this protected group because I want to focus on another protected group, essentially.
Got it. Okay.
Okay. And then an individual, by virtue of their protected category, bears personal responsibility for and must feel guilt, anguish, or other forms of psychological distress because of actions in which the individual played no part, but were committed in the past by other members of the same protected category. So this is like
explaining how people can feel.
Yeah. So I think where this is going, and again, I think this is more towards the education piece, because there were some articles that I saw in Florida news where children were coming home and they felt guilty. Their white children felt guilty about the history of slavery in America and Black Americans being affected by that. And that the rhetoric in the education programs was so strong that the children were coming home like distressed. So I think that's where this one comes from. Honestly, that's not something that I have yet seen, knocking on wood, as a workplace complaint by an employee, which you would think, again, that we would see some of these things as reverse discrimination claims, but that's not something that I have yet seen. But I have seen some training programs that address white privilege in one sense or the other. So that would be an area to kind of focus in on when you're reviewing your training programs to see if you could have some issues, is what does it say about white privilege? Does it say that everyone has it, or, what is the rhetoric around that subject?
Gotcha.
And then the last one is such virtues as merit, excellence, hard work, fairness, neutrality, objectivity, and racial colorblindness are racist or sexist, or were created by members of one protected category to oppress members of another protected category. That's kind of restating what this has already said, and that, are making the argument that the concept of colorblindness is not racist or sexist in and of itself. So I know that was a lot to digest, and we can kind of unpack it so everybody leaves here with a better comfort level.
Yeah, I think, I think we should, because as you were going through it, and that was great coverage of the 8 kind of aspects. That there's, I mean, obviously it can be confusing, right? And it seems like, and I'm no attorney, but it seems like, as you said, it's kind of already been covered. Is it even constitutional?
That's a great question. And there has already been a legal challenge to this act. And in fact, I think it was like 10 minutes after the act was signed into law by Governor DeSantis that there was a suit filed. And I think the plaintiffs are an interesting group, but you can see they're trying to cover both the education side and the workplace training side. But it's 5 plaintiffs, including 3 teachers, a student, and a consultant who teaches workplace trainings as their occupation, saying that this was unconstitutional because it's a restriction on freedom of speech, essentially. And there has been a hearing that was recently held on June 21st on this concept to say, okay, is this egregious enough to warrant a preliminary injunction, which would say, hey, state of Florida, you're not allowed to enforce this act until the lawsuit is finally decided. And that's something that employers may be familiar with, like with the OSHA ETS that was coming out and how it was stopped and enjoined, and you didn't have to do anything about it or worry about it until the ultimate court case was decided. Well, the judge actually denied the preliminary injunction. So right now it is effective as of July 1st, even though this lawsuit is still going on. And what the judge said, it's U.S. District Judge Mark Walker, and he issued an order basically saying that he couldn't halt the law because the plaintiffs had not yet shown an actual injury as a result of the law. Like there have not yet been damages associated with this. So I think it's interesting, but I do think kind of hearing where DeSantis and Attorney General Ashley Moody are coming from is helpful in knowing how they would enforce this act. And so I highlighted some excerpts of a motion to try to block this preliminary injunction that their attorneys filed. And what they're saying is what the act does, and all it does, is prevent employers from conscripting their employees against their will into an audience as a condition of their employment. The First Amendment may protect the right of employers and consultants to espouse the ideas that a person should be discriminated against on the basis of race, and that one race is inherently superior to another race. And it may protect the rights of employees to seek out, listen to, or share those views. What it does not protect is the ability of employers to use their economic leverage over their workers to force them to listen to such odious views on pain of losing their job. That is conduct, not speech, and the First Amendment has nothing to say about it. And once again, even if it did, the act would easily pass any level of heightened constitutional scrutiny, given the state's unquestionably compelling interest in eliminating open racial discrimination in the workplace. So it's pretty strong. I mean, I feel like this is a divisive issue, and most people are going to feel about it one way or the other. And it's clear how the state of Florida feels here, that employers shouldn't be mandating any kind of training that surrounds critical race theory. And that's really gotten the most attention, I think, out of all the subjects that potentially implicate this law. But it also goes on to say that the act surgically targets speech that the state believes reflects individual bias against certain employees on the basis of their race, sex, national origin, or religion. And it specifically specifies speech that the employee is forced to listen to or else suffer the consequences. So I think that's basically kind of where the state is hanging its hat, is that if employers are requiring their employees to believe these concepts as a requirement of their job and mandatory training, that's where you could get into trouble.
Sure. Is it believe them or listen to them?
So what the act says is to believe them or espouse them or adhere to them. And that's, I guess, where the rubber meets the road, in essence, of how are you going to message this to your Florida employees if you have trainings that could cross the line here. So I think there are a couple of ways to do it. One, there's been mention of using a disclaimer, right, to try to explain this training is intended to be presented in an objective manner. And regardless of the content of the training, employees are not required to believe, insert the 8 concepts that we just discussed. And I don't think that hurts you as an employer if you want to go ahead and do that in Florida. There's nothing ironclad that says it would totally prevent you from having liability, but it certainly couldn't hurt, right? And I think it could be used as a defense to say, we were just trying to present this in an objective manner and we didn't require anybody to believe these concepts. Yeah,
because I mean, how would you test? Like if you're the employer, so I'm the employer, and I have one of these trainings, DE&I training, which we do, we do them all the time for our clients, and like how would the employer prove that they're forcing someone to believe one of these concepts?
Right. So in my mind, you would have some documentation of the content of the training, and that maybe there's a PowerPoint program that you use to do the training, or maybe it's video recorded. So you have evidence of exactly what's said during the training so that you could say, no, we didn't require employees to believe this, and nothing in the training would have violated the act because here's proof of the subject of the training that we conducted. So that's going to be another important piece of having some kind of documentation of the content of the trainings, and then training the trainer, right, to make sure that they're aware of the requirements of this law so they don't go off script, so to speak. And it may also make you a little bit nervous about using recorded trainings if they're not vetted through your legal counsel, right? Because then you may have recorded something that would run afoul of the law.
Right, right. Yes, absolutely. I caught that look. Don't worry.
Yeah.
What are the legal remedies for a violation?
So that's another interesting piece of this, because the damages are the same damages that have always been available under the Florida Civil Rights Act. So typically when you see an employee file a charge of discrimination, they're looking for back pay, potentially front pay, and then maybe they say they've got some compensatory damages or their punitive damages because they've had emotional distress from being discriminated against. But, just being required to sit in a training doesn't really fit within all of those remedies unless they also argue something else, like, oh, I was denied a promotion because I didn't want to do the training, or I was fired because I refused to sit in the training that I think violated the Florida law. Then maybe you would get some of those back pay type damages. Otherwise, it's just going to be employees arguing that they've had emotional distress from being required to attend these trainings. And there are caps under the Florida Civil Rights Act for punitive damages of $100,000. So they couldn't go beyond that amount for punitive damages.
Gotcha. In theory, and I know this is just theory, but couldn't the concepts behind this act really kind of stretch out to include, say, non-harassment training or like harassment in the workplace training? It seems to be almost the same thing, frankly.
They could. And I think that's a really dangerous area, as you know, for employers, because you're doing these trainings and you're helping your clients have these trainings for a reason, because they provide a legal defense to a harassment claim, right? Or a discrimination claim. Because if you have policies that prohibit discrimination and harassment in the workplace, and you train your employees on those policies and let them know how to complain if they have an issue, and they don't come forward, well, then you have an affirmative defense as an employer to say, how could we have solved a problem we didn't know about, right? So certainly I don't want anyone to come away from this thinking that they should stop having harassment and discrimination training in the workplace, because I absolutely think that you should continue those concepts. I think it's really the examples that were given when this law was originally introduced as a bill were so extreme. And I'll share them with you because I think it's helpful context. But Governor DeSantis issued a press release that had these examples within them. And one of them is, and I apologize for naming any clients, and this is just straight from Governor DeSantis's press release, but Raytheon, the nation's second largest defense contractor, has launched a critical race theory program that encourages white employees to confront their privilege, reject the principle of equality, and defund the police. I don't really know where defunding the police comes into that. It's an odd one. But basically, again, that training is telling white employees that they have a privilege and that they can't be equal to others because they're inherently privileged, allegedly. I don't know if the training really says that. I've never seen it, but this is what the press release is alleging. Also, that Bank of America teaches that the United States is a system of white supremacy and encourages employees to become woke at work, and teaches that white toddlers have racial biases by the ages of 3 to 5. And also a Google employee program claims America is a system of white supremacy and all Americans are raised to be racist. So those are, in my opinion, very extreme examples. I haven't come across any trainings that I've reviewed for clients that have this strong language within them saying that, all Americans are racist, or if you're white in America, you are automatically a racist. But certainly if you had any kind of language surrounding that, or all men are inherently sexist, or all men over 40 are inherently sexist, or something along those lines, that's really getting to the heart of this, is telling one protected group that they are automatically biased against another group.
Yeah, super interesting. You sent me the links. I'm going to click on them to check out, because I can't believe that those companies would have trainings that say those specific things. That's right. Astonishing to me. So so you wouldn't train that, but so what is still permitted and recommended, frankly? So
definitely, like we talked about already, but you want to have your non-harassment, non-discrimination trainings in the workplace. And most of those are going to center around your specific company policies. What is prohibited by your organization? who do your employees go to if they have a concern? What's the investigation process like so that employees understand what to expect if they do come forward and report a complaint? And also, just making sure too that employees know that retaliation is also prohibited. So if they feel like they're being treated negatively after they make that complaint, what happens then? Like, who do they go to report that retaliation, and how is that resolved, so that your employees know what's prohibited in the workplace, they know how to complain. Hopefully you've got multiple channels for them to go to. So if they don't feel comfortable going to the supervisor, they could go to HR or an office manager or someone else in the company. And if it's still not resolved, they could go up the chain to the owner of the company or the VP of HR, depending on the size of the company, but giving them multiple avenues to go to if they do have a concern. And I think that absolutely should happen so that you have the legal defense there if an employee doesn't take advantage.
What's interesting, you mentioned that. I was thinking about some of our smaller clients with, maybe 100 employees and less. And there are not that many avenues, right? Because in a big, if you're Raytheon and Bank of America, sure, you can go to your supervisor. You can go, if you don't feel comfortable, you go to that person's manager. You can go to the director. Then you go to HR, et cetera, et cetera. But smaller firms really don't have that that many branches on their kind of employee tree, right, or employer tree. And when you're small, like that, as an employee, everything's going to get back to the owner, right? So I think it's important to have some sort of outlet that is even outside of that is outside of the organization, where employees can kind of make those complaints or claims or what have you, like a whistleblower hotline or something of that nature, or even like obviously Puzzle. That just makes it even more important to me for folks to have to build one of those kind of extra branches, as it were, hire one of those extra branches to their employer tree. So that's fascinating.
I think that's an excellent point. And I think it's also particularly important if you have employees working odd shift hours, right? So that they have a number or someone they can go to 24 hours a day while they're working. Because if it's a smaller company, there may not be anybody there at the time when they're working. So I think that's a great idea. And also keeping in mind, if you are a smaller organization and you do get that complaint that comes in and says one of your supervisors or executives is harassing another employee, how are you going to handle that? Do you want to turn to an organization like Puzzle or legal counsel to do that investigation for you?
Yeah. It's interesting. We got a call a while back from this company, did not become a customer, but they had I forget, it was either a harassment claim or a discrimination claim. And they called us to do some training for the employee who was implicated. There's the manager. And so I took the call to talk to the C-suite at the company. They're in Texas. And the question, and they weren't taking it seriously. And so the question I asked was, are you just looking to check a box, or do you actually want to fix this challenge that you have? Because if there's one person, there are two, and if there's two, there's a class action lawsuit. So, so are you going to really take, before we engage, are you really going to take steps to modify this individual's behavior? Because if you're not, then there's you're going to waste your money with us, Puzzle. And I certainly don't want us, I don't want to be called in a class action to testify. But yeah, so and that was a smaller organization, and they did not have, frankly, it's exactly what happened. So the complaint went out, it went right to the C-suite, and the owner was like, I've known this guy for 30 years. He didn't mean anything by it. I'm like, oh, okay, it's not the intent, it's the impact.
Right, exactly. And I think particularly since we're talking to a lot of Florida employers today, we have a lot of Spanish-speaking employees in Florida. So making sure that they understand the training and the policies, and they have someone they can go to that they can communicate with if they have a concern.
Yeah, absolutely. You mentioned adding a disclaimer to like training materials. Talk a little bit more about that.
Yes. So again, I mean, there's nothing ironclad that says, okay, if you put this language into your training programs, you're automatically going to be immune from any challenges to the training. But I do think adding a disclaimer is helpful rather than hurtful for Florida employers, because one, it shows the Florida Commission who investigates these charges of discrimination that you're aware of the law and that you're doing your best to comply with it, right? So if you have employees, normally you'll have them sign either an attendance sheet or a training acknowledgement whenever they take your workplace trainings. Sometimes it's virtual, maybe they click a box, but adding the language in there that they're not required to believe those 8 specific concepts that are mentioned in the law, regardless of the content of the training. I think that's helpful to show that, hey, even if we mention something within the training, it was intended to be objective and we're not requiring our employees to believe it. And I know that sometimes that's easier said than done, because a lot of employers have invested a lot of money in their diversity, equity, inclusion programs because they want a diverse workforce. And I think that's something that a lot of employers want, because it makes the organization stronger. You've got different perspectives, you've got different skill sets. So certainly I don't think Florida employers should just give up on their diversity initiatives. You just kind of have to be careful about the language and how they're presented. And some of it, I don't even think employers may have thought through how the language might sound, in the sense that with the concepts of unconscious bias, I have seen some programs that use white versus people of color as a common theme. And I think that has been, traditionally how we've seen these trainings organized. But you could present the same material, but instead of making it white versus people of color, make it one color versus another, or one race versus another. So it's not just pinpointing one group as the bad actor, but it's all groups need to be aware of this and need to be cognizant of the requirements.
And I think you make an incredible point. When we talk about diversity, equity, and inclusion, it's so much more than race, right? I mean, because it really just is. It really is just so much more than just that. Doesn't matter what your skin color is. If you grew up in the same neighborhood and went to the same school, right, and are the same age, you're going to have the same sorts of thoughts, opinions, and feelings, right? And so by creating a more diverse workforce, different people in your organization, from different walks of life or what have you, with different beliefs, you get a diversity of ideas. And I think that's really what makes makes organizations stronger, right? You don't have a whole bunch of people who think the same way, have the same ideas, and they're not just in that same echo chamber, right? You have people who can think differently, and really, to me, the idea of having a robust diversity, equity, and inclusion program in your organization is to just open up everyone's minds to the ideas and the feelings of everyone else, and that's just going to make your company stronger.
Absolutely, I couldn't agree more.
So this has been educational, right? At least for me. And I have your notes here, so I'm sitting here reading this, going by, and I had to mute at one point, and I'm just reading through it. And I'm like, wait a minute, what does that say? So Deanna, I want to say thank you for your time today. We spent 45 minutes talking through this, and much more to certainly much more to come. So I just want to say from all of us here at Puzzle to you and all of you at Ogletree, thank you so much for your time today, and look forward to doing this again real soon.
Wonderful. Sounds great. Thank you for having me again. Take care.
Thanks, Deanna.